It is good to have you back. If you are just joining us, this is Firecrackers and we are just getting started. Right now we have on standby Lagi Innocent, who is joining us live from Abuja. He is the former Attorney General, Minister of Justice of Nasarawa State. Good evening. Many thanks for joining us on the program at this time.
Yes, thank you for having me.
Okay, all right. Moving on to the topic we have at hand. A lot of criticism have trailed appeal court judgment, especially for state election. So, what are your assessments, especially for the ones that took place in Kano and Nasarawa State, which seems to be stirring lots of reaction from the public?
Yeah, I mean, like every other person, even as a lawyer myself, it is becoming probably more advantageous to go to a native doctor who will beat something or shake water and tell you what is there, than to go to a Nigerian court right now as it is on any issue that has to do with politics. Now, I say this with all sense of responsibility. The law is the law. It is nothing absurd. It is not a mystery. And the courts are not necessarily only the courts of law. They are courts of justice and courts of equity. Now, we can have our courts acting as if they are political parties or they are certain umpires in a wrestling game. This is about justice. The facts are there. Now, you need to match facts, wisdom, and public policy in order to arrive at justice. I give you an example, one that is very famous with the Christians. When King Solomon was confronted with the situation of two women claiming the maternity of a child, one wanted the child to be split amongst the two of them and let them take a piece of it. The other one wanted the child to go completely to the other person. Now, in Nigerian justice system, we are just splitting the child in the middle. You know, we don't care about the child, we don't care about the mother who will likely be the real mother, and we really don't care about, or we care only about the person who argues probably better or brings an argument that seems to satisfy the partisan logic. But outside that, I would say this as a matter of patriotism with the country. I am disappointed in some of the pronouncement of the appellate courts. It's so bad now that you wonder what will the feelings of the presiding justices that decided the cases, who had looked at these facts, who have seen these witnesses themselves, who had determined this. So nobody except the appellate courts know anything in this country. That is the way we're going. It is fast becoming a court of power and not a court of justice, because that is basically what you are saying. I mean, as lawyers, even as common people, when there is an infraction of a process of a law, it is very clear, and that is why people take it to court. To close your eyes completely to the infraction and look at technicalities, I don't think that is the purpose of justice or the purpose of the court system itself. Courts must be courts of law, courts of equity, and court of conscience and policy, not just necessarily a court that sits and determines who speaks better in a debate. Clearly, that is what we're having right now.
All right, very well then. Let's talk about what happened in Kano State, where, well, because after the CTC came out and then it was something different that was there. There was lots of uproar, and then the court is coming out to say that it was just a grammatical error, and then they have the jurisdiction to correct it. Although some people are saying that the court has no such power to do that. What are your thoughts on that? What should have been the right thing to have been done?
You know, a mistake is a mistake, and you cannot mistake. I mean, you can mistake being found in another woman's room other than your wife's room if you are not drunk or if you have not intentionally gone to that room. A mistake is a situation that is completely differently compared to the example I've just given you. You can't give an entirely different judgment, which, by the way, will suggest, as had been thrown out in the public even before that incident happened, that judges have two sets of judgments. Whoever pays them more, they read the one that suits the one that they get. This insinuation had been in the public for a long time. I'm not saying it for the first time. But clearly, for anybody who believes that, will believe that probably they gave one of the judgment and then they slipped and released the other one, because clearly that is it's not a mistake at all. For every mistake that I know of a judgment as a lawyer, and I've been doing this for 23 years, that a court will correct, it could be that my name was written in the place of the name of the other person. Not an entire judgment, not an entire reasoning, not an entire decision. And that was what happened in the Kano's case. It's not like they moved the name of the current governor and included the name of the candidate of the APC. This is a completely different judgment. It's simply that I woke up in another woman's room, and my explanation is that it is a mistake. So is it a mistake of drunkenness, or is it a mistake of mischief and just lies? So it really doesn't put the appellate court in a good light. This is not an area court. This is not a magistrate court. This is the Court of Appeal. That each of these justices have a team of assistants that work with each of the justices. You have the registry of this court. It is a big court. Mistakes like that cannot be accepted, even if it is said to be a mistake. This kind of mistake cannot, should not, and never should be expected from an appellate court of justice in any country.
Thank you. All right, very well. Now let's go to Nasarawa State, because the court reversed the sack of Governor Abdullahi Sule, and they were saying that it was wrong for the Election Petition Tribunal, that they erred in law in concluding that Abdullahi Sule did not win majority of vote cast, and then they threw out all the evidences that caused the sack of Abdullahi Sule in the first place, and saying that Nasarawa State is a state that you're very familiar with. What are your thoughts on what happened? Who should we blame then for this? Is it that the...
Of course.
Okay, please go on.
No, I mean, it is the appellate court. Let's look, as a lawyer, I'm resisting what the appellate courts are doing. The appellate courts are trying to show that they are the only people who know the law. They are the only people. I mean, we studied the same law with all the justices of the courts in Nigeria. I mean, we are all members of the same bar before we got appointed either on the bench or we remained in the private bar. We took the same curriculum in the universities. We studied the same thing. We are taught the same way, and we are supposed to apply the same laws in this country. So I give you an example. The law is very clear that the justices who look at these witnesses and understood their demeanor have the sole right to make the conclusions they will make on facts that are brought before them. The only time these facts can be reviewed, and I'll use the technical word, it is that it is if it is adverse. If it is such that it is completely unbelievable, or we can show that there's clearly a problem with the way the person reaches conclusion. But outside that, the appellate court had no power, for example, like in the case of Nasarawa, to decide that a judge who did not say that evidence was dumped or abandoned before me, to then tell somebody on appeal that the evidence were dumped before them. The people who received the evidence did not feel that the evidence were dumped before them. How can the Court of Appeal, for God's sake, that was not there, that was not the trial judge, that those documents are not presented before them, decide that the person who said these documents were not dumped before me, answer for that person that it was done before them? That is not a responsibility of an appellate court. An appellate court is to look at how those justices evaluate the evidence that was placed before them, not to say whether they received the evidence or not. These people collected this evidence and said the evidence were presented before us and it is evident. But this is the exciting thing about the whole thing. There were only one set of exhibits that were presented in the Nasarawa State Tribunal, because I was the lead counsel for the NNPP petition that challenged A.A. Sule. There was one set of evidence, one set only. Same evidence produced by the NNPP, same produced by the PTP, same produced by the APC itself. So there were no contradiction as to whether this evidence or that evidence is supposed to be different from another. All of us had the same evidence that showed that 61,000 votes were unlawfully, unjustifiably included to make the governor win these elections. All, including the dissenting judge who looked at it. Now, INEC knows it. As a lawyer, I know it. The parties we represented know it. Everybody knows, except the Court of Appeal that disagree, that 61,000 votes were unlawfully added to the APC. You can't come at this stage and the Court of Appeal closes its eyes to the fact that somebody was caught stealing. And everybody said that. Everybody. Everybody saw that. INEC itself gave documents that proved that. Now, how do you expect the perception of the judiciary to be with these common people who knew that? People who were in the polling unit knew that those were not the results of the elections. People who were in the tribunal knew that those are not the results of the election. INEC knew that those are not the results of the elections. And you have now declared the man, irrespective of those clear facts that were tendered before the tribunals. They were tendered, not even tendered, they were there. The court saw it, made a finding on them, and you are telling the court that saw it that they didn't see it well. It's really unfortunate, to be honest with you, and I don't know where we go to from here, because we can only imagine what will happen if the institution of the judiciary becomes unreliable and people will rather go to native doctors or go to mafia bosses to settle scores. And that is what we need to all watch out for. I mean, you can also imagine what the lower court judges who had spent days, who had sat hours reviewing the evidence that were before them will feel right now when this is done to them. Because you have caught a thief and then an appellate court set the thief free. For no good reason. For the things that, for saying that you didn't see what you saw well. And that, I do not think the Court of Appeal actually, and I know this because I'm a lawyer too and I was taught the same thing, has the power to unconditionally, or have an unconditional power to reverse the findings of a lower court. There are conditions, there are reasons why such decisions will happen. In the case of Nasarawa State, for example, none of the reasons they gave went to show that that was lawfully done in accordance to the appellate court jurisdiction over findings of facts of lower courts.
All right now, and since it seems as if a lot of people in the country do not like the judgment of the appellate court, and you would have to agree with me that this has eat the trust that the people have in the judiciary once more. This has been happening over time. So what recommendations would you give now to these people affected, and what do you think the judiciary could do to probably rebuild the trust the people are? Because, well, the judiciary is known as the last hope for the common man.
Look, I don't think there's anything one can do. I mean, I've made a joke in my class forum that, I mean, if the appellate courts think they are the best in the land, why do we have to have the lower courts? Why don't we just have one single court? You get one final decision as if it's God. You can appeal against any other one. But you see, it is not only the public that is concerned about what is going on with the appellate jurisdictions in this country. Look, everybody knows that Senator Lawal was not a party to, Lawal is not supposed to be in the Senate, for example. The Supreme Court made him that. We had argued about Imo State. We have argued about so many other cases like that that were clearly showing that our appellate court systems keep acting as if they are not in the country and they know nothing of this country, as if they are foreign to what is going on in this country. Now, so the problem is not just with the general public. So I give you one clear example. There is a problem even within the judiciary. So what do you want this, lower court judges to do or to think when anything they do appears not to be acceptable by the appellate court? For no reason, for example. I mean, if we see a good judgment, we see a good judgment. Everybody accepts the outcome. But the outcomes of some of these appellate judgments don't make sense at all. Look at Lawal Garba's case. Look at Kano's case. Look at Nasarawa's case. It doesn't just make sense. Are we rewriting the laws? And that was why I said earlier, what we are having now are really not reviews or some form of higher wisdom by the appellate courts. We are simply seeing them using appellate powers simply to overturn the decisions of lower court unjustifiably in most cases without good reasons for them for doing so. Because if a judge says, I saw it, the Evidence Act says the evidence of a person, the evidence of a thing that is sin must be the evidence of the person that says, I saw it. Any other thing is hearsay. This is elementary law. So if a tribunal justice sees an evidence before him and I say, I'm satisfied with this evidence, it is before me, wouldn't it be here appellate jurisdiction for an appellate court to say, oh, he said he didn't say it? Do you understand what I'm talking about? So you do not only have a problem with public perception, you are having a problem with the legal practitioner's perception of the court. You are also having a problem with lower judges having the same perception of the appellate courts. Because we are not being treated as if we know the same law or we apply the same laws in the country. It is simply a court of power. I have more power than you. I can overturn your decision, and therefore, without any justification, I overturn it, go to hell, or go to the next court, or what can you do? Basically, that's what's going on. So it's not only a public perception, it's an institutional disaster waiting to happen. Because why should I decide on a case if the Court of Appeal will overturn me anyway, simply because it has power? What's the purpose? Why do I sit as the court of first instance? Why do I represent the client when I do not know the criteria upon which decisions of this court will be made? So this is a very dangerous trend that is going on. It's simply not about public perception. It's not an issue of public perception. It should be an issue of what will happen if the judicial system stops working. And believe you me, it has stopped working as a judicial system. It is simply working as an institution of power.
And do we not risk lawlessness?
Absolutely. I mean, even now it is lawless. That's what I'm saying. You will get to a point where a court will give a judgment against a sitting governor and the governor will say, because it is not lawful, I'm not going. Or you will get to a point where judgments are given and they are manifestly unjust, unsupported by law, and people will refuse to obey those orders. And that is where we're headed to, because everybody knows, for example, in the case of Nasara, that this man stole votes. INEC knows it, they knew it, and then you are telling him he has to remain in power. Then you want to tell another person tomorrow that he's wrong for the same offense that this man had committed and you didn't do anything to it, to him? It's really dangerous.
Okay, all right. And we know that each arm of government, they're supposed to balance each other out. Now that it seems as if there are some malfunction, so to speak, in the judiciary, which arm now is supposed to be responsible for correcting these malfunctions in the judiciary?
Or up to deal with this malfeasance will be the executive arm of government. So let me explain. The National Judicial Commission, for example, is an executive body, though chaired by the Chief Justice of Nigeria, but all the other members are appointed by the executive of the president, that is, under the circumstance. Now, those are the bodies. That is supposed to be an independent body that holds judges accountable as to how they carry out the responsibilities of their offices. Now, but in the history of Nigeria, and we cannot remember anything in our recent history where any judge, either at the federal level or at the state level, that is punished for misconduct. But then day in, day out, judgment in, judgment out, there are complaints, loud complaints by the population, by lawyers, and decisions, even by decisions of appellate court, upturning decisions of lower court, to show that something had been done not correctly. And there's nobody who is being punished. So I think the major problem we have is that Unfortunately, in this country, the judiciary is becoming the only institution that is not accountable, nor held accountable, nor the mechanisms for holding it accountable exist. Because up till now, nothing has happened. Judges were arrested by the EFCC some time ago. We all criticize it because it is wrong, but nothing has happened. The idea was that if there is a complaint against a public officer, the complaint should first go to the Judicial Service Commission, which will investigate the matter. If it finds the judicial officer culpable, it can then either sack him or suspend him, and that will give give the police, give the EFCC, give the ICPC code of conduct power to then prosecute them. But that person must first be held account by the Judicial Service, either commission, committee, or Judicial Council. But in this country, we haven't had, in any recent history, with all the judges that are in all over this country, any case of misconduct that will serve as an example to certain judges. I give you an example. I was in court within last week. I swear to God, a judge listed all his cases on his course list. I had to travel from Abuja to that destination. 68 cases he put forward. People were brought from prison. Everybody who has a case before him was in court. Simply for this judge to want us to take dates. And he invited everybody to simply come to court and say, I will hear your case in February, in March. And there's nobody talking about that. Nobody's being punished about that. Recovery of premises cases, simple contractual relationship that lasts a year between a landlord and a tenant, lasts 3, 4, 5 years in court to be determined. And there's nobody or anything done to any of the judges who doesn't do that. Fundamental rights application lasts for years at the court of first instance, a decision that can be made instantly. And nobody is being punished or held accountable for that. So our judges are kings unto themselves, and they keep showing it, and that is why we have the situation we have now. The magistrate court judge thinks he's a king. If he gives a bad judgment, he can be overturned by the high court judge, and the high court judge, that magistrate is not punished. The high court judge makes the same mistake, it goes to the court of appeal, that decision of Tom, nothing happens to him, he continues staying, he continues doing the thing he's doing. The court of appeal justice does the same things we're talking about, he's not punished, the matter goes to the Supreme Court upturns it, nobody questions them. Even when they are going to be elevated, nobody brings those issues up to say, look, when you were in this court, or even the opportunity does not present itself for people to be able to say, when you were in this court doing this case, this was their decision, and this was what was said in overturning your decision. For the Supreme Court, they are gods unto themselves. Nobody can touch a Supreme Court justice in Nigeria, neither police, the legislature, or even the executive. Now, when you put so much power in an institution like that without putting as much mechanisms to hold the occupants of this office and those powers accountable, then you are going to continue to have what we're having. So right now we are hopeless with a situation where they will continue doing what they are doing. They won't be deterred from continuing to do what they are doing because we don't have a mechanism to hold judicial officers accountable or responsible for malfeasance in this country. The institutions do exist, but they are either corrupt, incapable of carrying their functions, or they are compromised and they therefore cannot do what they are supposed to do.
All right. When it comes to judiciary, some people have opined that the reason there are much problem is probably because of inducement by probably the executive or some other powerful individuals in the nation. And we know that one of the things that the judiciary has also been clamoring for is increased pay, because the cost of living, the amount, or even if the salary, if we are going to compare the salary they are earning in the past to what is obtainable now with inflation day in, day out, it might not really be the best at this point in time. And we also have people too who have been clamoring for financial autonomy for the judiciary. So if we are to look at inducement, do you feel like this is a valid point, or it should not even be something that we should talk about at all, since the judiciary is supposed to observe the law and, of course, give sentences without any form of inducement?
To be honest with you, other than political office holders, everybody's income, I mean, everybody's salary in Nigeria wouldn't take him home. That's the first thing we need to talk about. Everybody. So when you see legislatures talking about legislative autonomy, financial autonomy, what they want is a system where a chunk of the money that comes for the provision of governance and services in this country is given to them, and they will just share it amongst themselves. If the judiciary talks about the same thing, it's apparently the same thing we're talking about. How much is enough? If it is enough for the executive, it is enough for legislature, it is enough for the judiciary, and it is not enough for the public, what do you get? So, I mean, corruption and being corrupted are all the same things we're talking about. No judicial officer should go to work on a bike. No judicial officer should take a taxi to work. No judicial officer should sit in a courtroom that is not commensurate with a good law office. No court should be as rackety as they are in this country. No judicial officer should not have an accommodation security detail close to them. No judicial officers should not be able to pay or meet their family needs. Now, those are basics. When we are induced with our basic, we then think it is corruption, but it is the person inducing us that corrupts us. So there's nothing happening in this country, nothing is working except for the person who controls the money. I have a situation where I have to argue about judicial autonomy. So if the chief judge of a state, for example, becomes an accounting officer and a procurement officer for contracts for the judiciary, for purchases of daily needs for the judiciary, what happens if a dispute arises between the person they contracted to provide cars or fix courts with the judiciary? Who then sits in judgment? And what sense does it make that the person who you are accusing sits in judgment over a dispute you have with that person? So if the judiciary does not know that these are things that will happen, then it means the judiciary simply, like every other person, wants to just get the money and keep sharing the fortunes of this country and bringing it on its back. You can't have legislative autonomy, for example. We know the basic. All you need to do is budget what you are budgeting. The federal government must make releases in accordance to the income of the federal government, in accordance to what are top priorities for national cohesion. And basically, there's nothing wrong with it. So right now, the system is the judiciary suggests what the judiciary wants. The federal government puts it in a budget. The budget is passed by the National Assembly. The federal government will then have to, like in every other case, determine what are priorities for the time to do. A responsible federal government will understand that the judiciary, more than the legislature, provides direct daily life or death services for the country and ought to be financed more than the legislature is financed, because how many laws do we need to make in a year? How many laws do we even need to make in a country? That we keep spending the amounts of money we are spending on legislatures and not funding the judiciary that provides the day-to-day services that keeps us safe, keep our community orderly, and keeps us as civilized beings in the Council of Nations. So these are the issues. It is not about sharing federal government money for people to do what they want to do for their offices. We all, as institution of government, must first of all know that we owe a service and hold a trust for the general public of Nigeria, for the country, not to ourselves or our institution as it is being done right now.
Definitely.